Hello guys, I am Keshavini Anaparpan Ravindran. I am from Kulimkada. My IC number is 030604021054. So today I am telling about definition of the science of law and historical context and legal framework. Okay, let's start the science of law. Also, also known as jurisprudence, refers to the systematic, theoretical, and analytical study of law. It is focused on understanding the principal structures and function of legal system. As a science of law is approached intellectually, examining the nature of legal rules, their origin, purpose, consequency, logic, and impact on society. It seeks to explain what the law is, why it is exists, and explain what the law is, why it exists, and how it operates, often through socially research and critical reasoning. Okay, distinction from law as an art of professional law as a science is the theoretical. It involves law as the study of legal concepts, system, and doctrines in an objective, rational, and often plausible way. It is concerned with knowledge and understanding. Law as an art comprises the skillful application of legal principles like rhetoric or strategy. It involves creativity, judgment, and technique in interpreting laws, crafting arguments, solving legal problems. Law as a profession refers to the practice of law by lawyer, judge, and legal practitioner. It is practical involving silent reporting, court appearance, contract drafting of other real-world legal service. The summary is science of law study of what is law is and how it works. Art of law is how law is skillfully used in various contexts. Professional of law is practical day-to-day application of legal knowledge by professional. Each aspect is connected, but the science seeks to understand and explain. Law, the art involves using it effectively, and the profession involves living it in practice. Historical context and legal framework is the evolution of legal science has been scientifically shaped by key jurists. John Austin, 1790 to 1859, introduced the common theory of laws, defining law as common issue by a sovereign backed by sanction. It laid the foundation of legal positive separating law from morality. And also Hans Kelsen, 1881 to 1973, developed the pure theory of law, arguing that the law should be studied as a normative system independent of politics, morality, of social science. He introduced the concept of the Grundnorm, basic norm, as the foundation of legal system. HLA Hart is 1907 to 1992 critiqued Austin theory and refined legal positivism in his work The Concept of Law. He introduced the distinction between primary rules application and secondary rules raised about rules, especially the rules of recognition.
Hi sir, I'm Sania here. I want to present about the case study medical ethics and end of life decisions. The moral of in situation involving internation or situation as suicide, individuals and their family often comfort deeply held moral benefits about the right to die broadly autonomy and the sanctity of lives. The legal dilemma positive law may secretly prohibit such a practice, framing them as legal acts regardless of the completed intent behind them. Application of legal positive argument for strict adherence or jab or legal shoulder operating and under a secret positive view will focus on the written publication of intonation arresting that any argument for these allegations must be made through allegations, not through appeals to morality of personal ethics. Thank you, sir.
Hi, good day everyone. I'm Ishwari and I'm going to present about the definition of politics and nature of politics in science. So how about the politics? So basically politics is the process of making decision for society. It is about power, authority and resource distribution. So how about the nature of politics in society? So basically politics is a social activity and then it involves conflict and cooperation. It deals with power and authority, and the last one is it is universal and always changing. So and then we're going to present about the scope of politics science, and here got 5 scope of political science. So the first one is it studies political theory and ideas, and then it compares governments and system, and then it explains public administration. The fourth one is it covers international relations. It is studies law and constitution. And then we're going to tell about relevance to governments. The first one is helps create good policies. The second one is promotes democracy and rule of law, and then ensures accountability of leaders. The last one is encourages citizens participation, and the last one is relevance to law enforcement. So here got also 4 relevance. The first one is guides fair use of power. The second is protects rights and justice. The third one is promotes ethical policy, and the last one is maintain peace and order. So that's all my part. Thank you.
A very good day I'm wishing to Sir Denial and also my colleagues. So today I'm Rahini, daughter of Krishnan, going to present about a recommendation and reform proposals of science of law. So as we see, recommendations for science informed law reform include using data to identify legal defects, incorporating diverse research methods, so like international models and also academic studies, engaging stakeholders through consultations, and ensuring reforms align with principles, so which is simplified, updated, and more accessible justice. So reform proposals typically result from a systematic law reform process where a reviewed body from such as the Law Reform Commission examines the law against specific goals. So before making recommendations that are submitted to the relevant authorities, so such as Attorney General or Parliament for consideration and potential implements. So recommendations aim to correct flaws in existing laws and also make them easier to understand by the administrator. So a core goal is to improve citizens' ability to access the use and legal system effectively. Okay. Yeah. So the next one is recommendations must address the specific policy objectives set out in the review's term of reference. So that's all from me. Thank you.
Good evening everyone, my name is Tisha James. Today I would like to share about 3 improvements that can make legal understanding and practice better for society. The first is we need more legal awareness campaign. Many people do not fully know their rights and this often leads to them being taken advantage of. At the same time, citizens also need to understand their responsibilities such as following the law and respecting others' rights. Campaign through school, community events and even social media can make this knowledge more accessible. When people are aware, they are more confident and able to protect themselves. The second is we should encourage the use of technology. The legal process today can be very slow with long waiting times and heavy paperwork. By using digital tools, such as online case tracking, electronic filing, and even virtual hearing, the system can become more faster and more transparent. This not only saves time for lawyers and judges but also help ordinary citizens who may not have the resources to deal with the delays. Finally, we must work on simplifying legal documents. Too often, law and contract are written in complex language that only legal experts can fully understand. If these documents were written in plain, clear words, everyone could understand them without fear or confusion. This will make people more willing to engage with the legal system instead of feeling excluded from it. Thank you. That's all from me. Thank you.